And we're recording. Recording? Okay. I don't know if we're recording or not. I'm going to give me one more second to make sure we're recording.
I see you're recording. The recording
Okay, good. All right, there we go. Hi, my name's Tom Reynolds, and I'm from the Reynolds Group. We do marketing and things like that, which means we combine sales and marketing to help people increase profitability and sales. I've been running a weekly event for the last 69 days to help businesses with different issues that are arising during this very strange COVID-19 period. Today's speaker is my friend, Rochelle Golden, who I thought was a cousin at one point, but turned out wasn't, but I'm still calling her cousin. She's a great business defense attorney and has extensive experience in consulting private and public entities in proactive ADA compliance, which includes creating policies and procedures that comply with federal and state laws. Rochelle has a successful track record defending clients against lawsuits relating to all aspects of American with Disability Act. Rachel also handles labor and employment law and litigation. She defends employees before state and federal and administrative agency and provides counsel regarding all aspects of human research issues and compliance to help clients avoid penalties and litigation. So before we get started, I would appreciate it if everybody would stay muted. The other thing is that the speaker is going to talk for about 30 minutes, and then my co-host, Linda Feinholz, is going to slow things down a bit, let you ask some questions. If you have a serious question, you know, I could share my screen and you could all see this, I suppose. But anyway, if you have a serious question, please, in the chat room, that's where you should ask your questions, on chat at the bottom there. Write the word question in all caps, and that means that you really think this is important and should be asked during whatever Rochelle is saying. And if you have any questions, if you want to write this down, my phone number is 818-371-5311. If you text me, if you have a technical problem, I'll be more than happy to try to help you. So with that, I'm going to turn the meeting over to Rochelle and let her do her thing. Thank you.
Hey everyone, I'm going to share my screen and it's going to block me out. So let me just, if you could, you know, if somebody could respond that they could see my screen, that would be fantastic.
We see it.
Okay, wonderful. Let me make sure my timers are off. Okay, cool. Okay, you guys can see that okay?
We can.
Wonderful. All right, so as Tom introduced me, my name is Rochelle Golden. I'm an attorney in Fresno, California, but I practice in all state and federal courts in the state of California, and I'm currently waiting to be admitted into Washington, D.C. So my passion here is to really kind of help businesses grow. And so before we get started and I kind of dive into the meat of this, I want you to know that while I'm an attorney, I'm not yours. And so if there are specific questions about your particular, you know, your website or your mobile app, or if you've been sued or you get a demand letter or whatever it is, and you need to seek actual legal advice, feel free to contact me directly after the presentation, and I'd be happy to answer any questions that you have. So this is truly just educational, and that's the lawyer disclosure. So sorry to bog you guys down with that. As Tom said, I represent businesses throughout the state of California for ADA defense and also employment defense law. I suffered a spinal cord injury when I was 15, and so I was kind of thrown into a world of disability that I hadn't really been a part of in the past. And so, you know, people assume that I'm a plaintiff because I use a wheelchair, but I'm not. So I'm actually a strong business advocate and do some lobbying and things like that for the Civil Justice Association of California. So while there's a lot of content here, I will be very surprised if we get through all of it in 30 minutes, because again, I want to make sure that everybody's questions are answered. We are going to do a part 2 next week with the remainder of the presentation. And if you need the slides or anything like that, just go ahead and shoot Tom an email, and I will make sure that those slides get to you. And so again, there's a lot of content, so I'm going to kind of go fast, but at the same time try to make sure that it's beneficial for everyone here. And I will also talk about at the tail end of the presentation, whether it's this time or next time, kind of about the new website accessibility law that's coming down the pipeline, so that all of you can be aware of what California is doing to address this issue. So with that, let's talk numbers and why this issue matters. Okay, so as we all know, we are in the COVID pandemic, and there's so many businesses hurting. There are so many businesses closing. There are so many businesses that are having to think outside the box as trying to figure out how they can accommodate all their customers and still keep sales up. And, you know, accessibility for a lot of these businesses is just not in their brain. They're just surviving, which is totally understandable. But with that being said, if you are hurting, why wouldn't you or your company do everything in your power to boost revenue and reduce the risk of litigation? Because most often, even in a healthy economy, these lawsuits, these predatory lawsuits, as I call them, will wipe out a business. That's completely outside of the COVID crisis that we're in. And so if it can wipe out a business in a healthy economy, why don't we do something that we can to preserve everything that we have and that we've worked so hard for? And think of this presentation as kind of like your insurance policy. If you invest in your business and you invest in your website and your mobile applications, then you're also investing in reducing your risk of litigation. And so it's really important to keep that in mind as we go through these. So just to give you some statistics about potentially boosting your revenue, there are 51, these are from the 2002 census. We haven't gotten the 2019 census numbers yet. But in 2002 census, there was 51.2 million people who have disabilities in the United States. I saw another figure where that was about 1 in 6. So there's about 21% of people throughout the United States that have some sort of disability, whether it's mobility, cognitive, hearing, speech, whatever that is. And so that's a lot of people. So yeah, more than 1 in 6 of those are potential customers. And as people are living longer, and with environmental factors such as autism and cerebral palsy and things like that, you have a lot of children who are going to be living a lifetime with disability. And so, you got to start now in order to really kind of capitalize on the discretionary income, which is on the next slide. It'll blow you away how much money is out there waiting to be had. And so by 2030, there will be more than 63 million people who are 65 or older. Well, what does that mean? That means that people are going to be becoming disabled later in life, potentially. You're going to be taking care of somebody with a disability. It's going to happen in your family. So this is an issue. While it may not have touched your business or you personally yet, it certainly will by the time you become older. And so these are people who typically have, especially in COVID, underlying medical conditions, right? So they're the people that have weakened immune systems, that maybe are battling cancer, some sort of, kind of acute situation. These are people that maybe not be able to really social distance because they have to have people come into their homes and help them. So what are they doing? They're relying more and more, especially right now, on mobile applications and internet online sites, because that's the only way at this point in time that they can function. They cannot go out of their house. So it's really, really, really important to take a step back and to really look at, okay, if I were in this person's shoes, what would I need in order to succeed in purchasing a product from me, or utilizing a service, or having some sort of e-commerce interaction? So just keep that in the back of your mind as we go through kind of what the law is, what some businesses are doing, what some suggestions that I have are. And again, this will probably be a 2-part session because there's quite a bit of material. But let's talk money. Okay, now we talked people, now let's talk money. This is in 2003, okay? So the census revealed in 2003, because there was a two-part release, that people with disabilities had $175 billion in discretionary spending. With the aging population living longer, that number is only going to increase. There is only going to be more money out there for grabs. An estimated of 35 billion was estimated to go to restaurants. That's a huge number. People are eating out more and more and more with your grab and go and drive-throughs, and you know the dynamic of entire households now working is that number is again just going to increase. 13.6 billion is estimated to have been spent on traveling. So that's in your hospitality industry, whether you're in a airline industry or the train industry or rideshare, whatever. That's transportation, everything. So traveling is huge. And the AARP estimated that 50 people who are 50 years or older spent $400 billion. Okay, nationally. So it seems kind of simple, but it's worth noting people who are alive spend money, okay? And with the average life expectancy of almost 80 years old, that was the CDC's number in 2017. As people are getting older, there's just more opportunity there for your business to grow and the bottom line of your business to grow. So again, keep that in mind of the framework of yes, this is going to seem daunting, okay? I'm gonna just be very upfront with you about it. It seems complicated and daunting, and I understand that. But hopefully by the end of this presentation, you will then think, okay, this isn't so scary. People with disabilities and kind of changing some things around are not so scary. So if I've done that by the end of the presentation, it is a win, and I'm thrilled that you come away with that. If there are lingering questions that you have about maybe some strategizing and things like that after the presentation that you want to kind of brainstorm about, like I said, my information will be at the back end of the presentation. You can certainly reach out to Tom for the Reynolds Group. He would be more than happy to answer any questions that you have, because this is his bread and butter. This is what he does all day long. And so you are now being equipped with a team who will be able to help you kind of navigate through some of these more complex issues. So what is this thing? Okay, what is the Americans with Disabilities Act? Most people associate the Americans with Disabilities Act with construction-related aspects and elements like ramps, parking stalls, signage, all of those things that you've heard about, these drive-by lawsuits. Well, the Americans with Disabilities Act was enacted in 1990, and it said that people with disabilities need to be able to be afforded the opportunity to purchase goods, access services and facilities, privileges, advantages, or accommodations, just as people without disabilities can do. So it's just an inclusive law. It's an amazing body of law. Me being in a wheelchair, I would not be able to function in this world without it. I rely on it every single day, and I'm super grateful for it. But with that being said, there are a lot of bad actors out there. Not everyone. It's a small number of people. So don't see somebody with a disability and immediately panic, okay? There are a small group of bad actors who are giving us, the rest of us with disabilities, a bad name, unfortunately. And that's really kind of been the driving catalyst of these lawsuits, has been to extort quick and easy settlements from people, and we'll kind of talk about that in a minute. But then there are those who actually care about making something accessible to them, and those are the people that you want to do business with, because those are the ones that are gonna ask for an accommodation and work with the business, so that way there's a healthy business client relationship. So, and that's what the Americans with Disabilities Act was meant to do, was to foster that kind of healthy relationship. So again, no individual with a disability is excluded or denied services or segregated or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. This is where the website piece comes in under the Americans with Disabilities Act. Granted, like I said, it was enacted in 1990, and so at that time, the legislature wasn't contemplating website accessibility, but they certainly were contemplating the TTY system, which is a Braille telephone system. They were certainly contemplating closed captioning for movies and television shows. They were certainly contemplating maybe American Sign Language interpreters. So all of those auxiliary aids, those communication aids, is what the legislature was contemplating at that time. And as technology has changed, the courts are saying, okay, we need to keep up. We've got to, if online accessibility wasn't even, it didn't even exist because, AOL, I was in junior high, I think, when it, or maybe elementary school, when it was dial up with the, your phone line had to be all hooked up and it was horrible, right? But nobody, I don't think, appreciated the fact that, that the internet was going to be such an integral part of our lives. And so as technology has changed, the law is now changing. And so that's really this effective communication piece is what people are relying on to say, hey, wait a minute, I can't access your website just as anybody else can. I need to have food delivery service too, and I'm blind, or maybe I'm blind with a mobility impairment. Maybe I'm blind with a cognitive impairment. Maybe I'm deaf and, there's some sort of visual component to your website that I can't hear. And if you don't have closed captioning, I'm totally excluded from that. And so again, as technology changes and the technological aids keep getting more robust for people with disabilities, the law is now catching up. And so that's really the background of this whole issue, okay? So the legal framework is this. The Americans with Disabilities Act is federal law. It applies to every single state in the United States. You can only get injunctive relief under the Americans with Disabilities Act, so it's only a person suing somebody else in order for them to change something. It's prevailing party attorney's fees, so if you as a defendant get a defense verdict at trial, arguably you would be able to get attorney's fees and costs, but 99.9% of the time that doesn't happen because a court is not going to take money from a plaintiff who is advocating for their civil rights unless it was an entirely frivolous case, which is very hard to prove. So while the statute says prevailing party attorneys fees and costs, that's not really a thing. That is the exception to the rule. Here in California, we have the Unruh Civil Rights Act, which is injunctive relief, prevailing plaintiff only attorneys fees and costs, and it's $4,000 per occurrence. So what does that mean? Okay, well, if this were an actual facility, if somebody was driving by my law firm 3, 4, 5 times, total, it would be 4 times 5, right? So it'd be $20,000 just in the statutory penalties. That doesn't mean per violation. So that doesn't mean we're compliant, mind you. I made sure of that. But let's just say that my signage was not right in my parking lot at work. And maybe the door pressure was more than 5 pounds. It wouldn't be $4,000 for each of those items. It would just be per visit. And the same is with website litigation. California is not going to allow $4,000 for the failure to have alt text. Maybe there's a timing situation on your website that you can't disable or slow down. It's not $4,000 for each of those violations. It's truly per visit to the website. But what happens? Most of our plaintiffs are in New York and Florida and Arizona. Okay, those are the 3 states where the most heavy hitters are, and they're suing California businesses all day long. So what does that tell you? They're sitting on their couch and just trying to find websites that don't comply with the standards, which we'll go through here in a minute. What happens if you're a California business and you're selling, shipping, providing services to people in New York and Florida, and you get sued in Florida, or you get sued in New York? Okay, the laws are different in those states. And so you may be faced with a situation where you're potentially having to defend a lawsuit across the country. Arguably, you could get that case transferred because your principal place of business is in California, and your primary client base may be in California or what have you, and you have no real true connections to New York other than the fact that you ship there. But that's something that is certainly possible and certainly happens. And people will use those laws because the laws are more lenient in those states than they are here in California, surprisingly enough. So, some things to think about. This is an issue where it can become very, very, very costly very quickly if you don't take what we're saying to heart and really employ these kind of these suggestions and recommendations, and now becoming the law. So, so what is the standard here in California and now nationally? The Americans with Disabilities Act doesn't specify, what you should do. It just says effective communication, right? Because website content accessibility guidelines, the acronym is WCAG, WCAG, that didn't exist when the ADA was enacted. But so what's happened is WC3 is the World Wide Web Consortium, and it is an international panel of people from all different industries, and they come together and provide guidelines. Okay, this is not law. These guidelines are not law, but it gets tricky when we talk about, we will in a little bit, about the Robles versus Domino's case. They present these guidelines that says, if you do these things, we determine that you will be as accessible as we can think of. Okay, so as of 2018, the website content accessibility guideline commonly used was 2.0 AA. This is all mumbo jumbo, but just remember it was 2.0 AA. We'll break down what this means here in a minute. But recently in 2019, they released the 2.1 version, which is actually more mobile friendly. So if you haven't done anything to your website at all, and you haven't done anything to your mobile app at all, and you're using an entirely outdated, website, mobile app, the whole 9 yards, it's in your best interest to create something new that complies with 2.1. Maybe you phase it, maybe you do some staging where you've got, hey, we're under construction, but in the meantime, here's some services that we provide, and we're providing equivalent access, and, give us a call, we'll do whatever we can while we're making this transition, okay? The point is to communicate changes with people with disabilities so they know we're working on it, the business is working on it, we're not trying to exclude you, we're in the process, so give us some breathing room. If you've already complied with 2.0 AA, to go to 2.1, my understanding is it's not that much different other than for mobile applications. It's a pretty significant change for mobile apps, but as far as websites go, it's not that much different. So that's what WC3 does, the World Wide Web Consortium, is they present these guidelines. The Department of Justice was going to issue a guideline. They had a proposed rule in October of 2016 rather, and then they took it off of their agenda basically. But within that proposed rule, guess what? They said WCAG 2.0 AA is what we're going to consider to be accessible. While they took it off of their agenda, they certainly are not shy, or hadn't been shy. It's a different administration, different time, different issues, but had not been shy about filing amicus briefs on behalf of plaintiffs, supporting the fact of, yeah, well, we haven't really said, we haven't officially said that we want to, WCAG 2.0 AA to be the standard. That's kind of what we really want. So we're just going to go ahead and file a friendly brief in this case and make sure that the court understands that we're advocating for this position, even though we haven't really set out a formal rule. You have the House of Representatives who have sent letters to the Department of Justice saying, please, for the love of God, tell us what it is that you want, because our businesses are drowning because they don't know whether it's WCAG or not. They doesn't, is it 2.0 period? Is it 2.0 A? Is it 2.0 AA? Is it 2.1? What do you want? And the Department of Justice said, yeah, we're not really going to comment on that. It's up to the business to provide effective communication. So it depends. Thank you very much, United States government. Perfect. So with that, though, there is potential leniency for how you provide that communication if you are unable to provide WCAG 2.0 AA or 2.1 level of website compliance. And so there is an opportunity here for businesses to really get creative, especially in a time that we're in with COVID-19, to really think outside the box on how are you going to provide these services in a way that will communicate to anybody, regardless of their disability. And so it's kind of a unique opportunity and a unique time to really get creative and brainstorm about your business, which is kind of fun in a way, actually. So what happens if you leave this conversation and you do nothing? Okay, this is just California. Okay, these are just this is California. This is not Arizona. This is not New York. This is not Florida. This is California. If you were to be sued in California, most of these cases now we're seeing being sued in state court, because state court law is different than federal court, which is different than your construction related access claims. You remember those ramps, signages, or signage, accessible restrooms. Those cases are brought in federal court because they don't want to jump through the hoops of doing demand letters and its statutory procedures that they have to comply with. They have to notify the California Commission on Disability Access if they're a certain kind of litigant. So they don't want to do that headache. So they just immediately go to federal court, but then they kind of bootstrap their state law claims so they can still get their money. With website litigation, they're filing in state court because that pre-litigation demand letter doesn't apply, because that's only for construction related access claims under a specific code in the civil code. But because in the state court, state law has said, you don't need to have a nexus to a brick and mortar. Your website, if you're purely an online business with no brick and mortar, then you can be sued. Federal court, as we'll see in Robles versus Domino's, says, no, there has to be a brick and mortar. You can't be sued without having a physical location in the Ninth Circuit, which is a very conservative point of view, actually, which is surprising for our Ninth Circuit, because they're usually, they are one of the most liberal circuits in the country. So it's kind of an interesting dichotomy that we're seeing here. So with that being said, the plaintiff is inevitably going to ask for at least $8,000, because they're going to say, I visited the website at least twice. And then if you settle, you're going to have to pay their attorney's fees. So that $8,000 jumps to $10,000 to $12,000 to $14,000, $15,000. Plus you still have to hire an attorney. So you're still paying yours. And then you still have to become compliant, right? So let's cut out all of that. And why don't you come up with a plan and a budget and actively work to become compliant now? Because that is the only way your business will save money. And so there's a debate whether class action damages, whether those are allowed or not. And, some lawyers will say, no, they're not allowed, but then there are other lawyers that will say, yes, they are allowed. So it could be a situation where you're facing a class action lawsuit against maybe the National Federation of the Blind, right? I mean, that's a class action. So how are you going to allocate $4,000 per class member? I mean, it can jump up really quickly. And typically they go after the big chains like Target and Best Buy and things like that. And they actually do really great work. I mean, they represent people who are truly blind or who are truly some sort of communication barrier that says, hey, Target, hey, Winn-Dixie, I can't order my prescriptions through your website. Can you please make it accessible to me? So there is some, I don't want to say legitimate, but there are some people who are truly trying to make it more accessible for people with disabilities. But then there are those bad actors who just go after the $4,000 penalties all day long, sitting on their couch saying, well, I was going to go to a hotel in Tulare, California. Really, for what? If you're living in Arizona, what brings you to Tulare? Please let me know. So, so this is really the kind of the cost of the cost of burying your head in the sand. So now that we've done the framework, what does website accessibility even mean? Okay. So what happens is when a person has an auditory or hearing, that auditory and hearing are the same things. That's redundant, I apologize. But an auditory or cognitive or speech impairment, and cognitive can be physical as well. So instead of just communication barriers, there's a lot of people with cerebral palsy who maybe have some limitations mentally, but they also have some pretty severe mobility disabilities, and really need to use speech software like Dragon, or they really do need screen readers because maybe their vision has been affected. And so they, use JAWS, which is a screen reading software. So those, people with those types of disabilities, a lot of times are unable to access the goods and services of a website because a website is not compatible with their assistive technology. So if you code your website to be WCAG 2.0 AA or 2.1, you will then have been deemed to be accessible for all current assistive technology for people with disabilities. So screen reader is something that is something that the user buys. So the person with the disability buys it, they attach it to their system, and it literally will read the screen aloud to them. So right now, their screen reader would be saying from top to bottom, so what does website accessibility even mean? Website litigation arises when a person with and it will read the whole screen to them. And then there are also features where they can skip block content that appears on multiple pages, just as you and I would, that don't have sight impairments, where somebody may be looking for one thing and then that content is repeated on multiple pages. Well, you don't want to read that over and over and over again, so you skip it, right? So their screen reading software has the ability to skip blocks of content that appear on multiple pages. Maybe they use only the keyboard because they don't have manual dexterity to use a mouse. Maybe they can't move their arms, but they can move their fingers. Well, if you're coded to be compliant with WCAG 2.0 AA or 2.1, then that website should be navigable with only a keyboard. Okay, a lot of times a website will start off being compatible, but then they'll get to one place and then they can't get back because it gets stuck because links are broken, or maybe they're trying to click on a URL that's coded properly, but then when they click on that link, it's broken. It doesn't take them to that external website or that other page. And so that would be incredibly frustrating if you were trying to access a website and you got stuck, or you couldn't access a URL. You'd be like, I'm never coming back here again. Just as if for me, if I'm going to a restaurant and there's not an accessible bathroom, it's off the table. I'm not going back there again. So what does that mean? I'm not going back there again. My friends and family aren't going there with me. Your bottom line is dropping. My parents won't go to places where they know that I can't go, even if I'm not with them, just because it's out of principle. You should be accessible. So what does that look like for website accessibility? It's the same thing. They can't access it. They can't access your business. So why wouldn't you do everything you can to make sure that everybody can access your business so you can provide the goods and services and help your bottom line? This is the same for educational institutions. I saw that we have some charter schools attending, which is great. I mean, moving things online right now through this COVID time is wonderful, but have you tested the accessibility features on Zoom? Have you tried it? Have you tested the accessibility features on Microsoft Teams? Do you know if those have closed captioning for people with auditory impairments? They do, but do you know how to use them? Do you know how to work them? So, Linda, you're on mute. I don't know if you meant to say something. Oh, you're still on mute.
Can't hear you, Linda.
There we go.
There
The
we
space
go.
wasn't working. Hi, Rochelle. Rochelle, I have a stack of questions that are coming up, and since I know you're going to join us again
Sure.
next week, I don't know how many more slides you had. So what I'd like to do is pose the questions, and then you can let us know whether it makes sense to address any of them today or to carry them over to next week.
Sure, go ahead.
And then I know Tom also has a poll that he wants to give everybody. So here's the questions that are coming up. So in what arenas can a business declare, we're not ADA accessible, that's not our business model? Are they allowed ever to say that? So that's one.
Absolutely not.
Okay.
No,
Okay.
you have an obligation. If you are open for business, if your business affects commerce in any way, shape, or form, I'm not talking about a standalone blog where there's no transaction, okay? But if your business conducts any business, collects $1 from one person, you absolutely have an obligation to be physically accessible if you have a brick and mortar. And now with Robles versus Domino's, which we'll talk about next time because it's already been 30 minutes and we might have to do a 3-part here. You will need to become compliant with some sort of effective communication, preferably WCAG 2.0 AA.
The next question is, a lot of folks, myself included, have built our online presence through larger system portals where we're building funnels on their portals and so on. So obviously it's our responsibility to check with them if they're paying attention to these things. But if the site is in some fashion, in someone's experience, not accessible enough, who's responsible for that? Is it us, or is it the site that's the coder of their site and so on?
Right. So there's not been cases, well, a lot of times what happens is within your use agreement, when you click on the I understand the terms and conditions, right?
Mhm.
You're subjecting yourself to an arbitration agreement with that company. So what, and again, my dogs are going crazy. I'm so sorry. So if you use that, let's say you use WordPress and you choose a template that's not compliant, arguably what the court is going to say is, because they're going to analogize it to a landlord tenant, right? So if you have a tenant that's renting a space and the landlord owns the property and you have a lease agreement with your tenant, the law is very clear that says the tenant and the landlord are jointly responsible to the plaintiff, because that plaintiff is not a party to this contract between you and the landlord.
Mhm.
So what my educated guess is that the court is going to say, I don't care who you use. It's your responsibility to make sure that you have an accessible format. And if you think that you've been wronged in some way, or you didn't understand that you weren't getting an accessible website, you need to then go after that company, which will probably subject you to an arbitration agreement.
Okay.
So, but every business has the burden and the obligation to make sure that they're using websites in an accessible way, regardless of whether they start from scratch with their own coding system or whether they use a template.
I know that Tom has got a graphic design point of view question that he wants to ask, and I have another question here. You brought up the issue of closed captioning. Well, if I have, for instance, YouTube videos embedded on my site, or I am giving people a hyperlink to go watch a YouTube video, exactly what is it that someone who's using that kind of technology has to do in terms of closed captioning or alt text and on image
Well,
design?
YouTube is compliant, and so YouTube, if so, what we recommend is, because we know that Facebook is compliant, LinkedIn is not, okay, Instagram is not, but Facebook is. And so if you're struggling with, like, how am I going to do this? Maybe you move a lot of your content onto Facebook and use a platform that is accessible. Maybe you put on your homepage, we're working on providing a more robust website for persons with disabilities. We want to be accessible to all. In the meantime, please visit our Facebook page at blah, 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 blah. And you can access, our menu. You can make online reservations because there's a link to OpenTable, or whatever that may be. You can advertise maybe new educational courses that are coming down the pipeline if you're in the education realm. Shifting everything to an accessible format is really a great option, because there are good options out there while you're in the process of creating a budget and going through the planning phases of your website.
Great. Tom, your questions.
Well, actually, two things. One is that just real quick, I want to throw out some things to Rochelle that we're doing for ADA compliance, because there's all different levels of this thing. And I think if you give it a good college try and you're a small business and you do some simple things, that it goes a long way in terms of people appreciating it. So Kurt Doty, who's on my design team and strategy team, is on the call, and he's done some work for the federal government. I was just going to have him run through a few of the things we do design-wise and have you comment on it. Rochelle, is that okay?
Sure.
Okay. Kurt, if you're there, unmute and talk.
Okay, can everyone hear me?
Yes.
Yes.
Okay, great. Thanks, Tom, for the opportunity. So having dealt with this for a few years, from a graphic design perspective, specifically to websites, it's really using common sense. And certainly from a basic vision, need for people to be able to read the communication. There's some common sense things that, generally, if you have a yellow panel of color on your website and you want to put some type in there, well, guess what? White does not read against yellow. There's not enough contrast, visual contrast. So most people cannot read that. People who are impaired can definitely not read that. And so there's some formulas, derived in websites that you can submit some of these basic design components and get a rating or approval that builds a best practices in terms of what designers should be thinking about when they're designing sites. And so you want to be as clear, as bold, and legible as possible. The days of, I'm a designer, I want to have some really cool little type in here because it looks cool. It's like, nope. If you can't read it, if someone over 50 can't read it, or people with, that are visually impaired can't read it, you got to boost it up. So there's all kinds of minimums, font size, but also this color blocking and type against colors as well as photographs becomes a big issue. And you have to be very overt in your solutions and your design process to really provide effective solutions to combat this. And a lot of it is common sense. It's like, am I having trouble reading it? Then someone else is going to have trouble reading it. So adjust the color, or just lose the color bar. Like right now, your headline there, the white is white against blue. That probably is not going to pass the test, certainly on a website. So these are things to think about. Maximum contrast, as big a type as possible. Many apps are giving consumers options to, you want to display the larger text, which is fantastic, because then it puts them in a choice that they choose to use the larger type. But that's not on every site, and it's not on every mobile app. So that's my graphic design point of view. So please tell me if I'm wrong or crazy, or any elaboration.
No, not at all. That's exactly right. And, even on this, I was telling Tom, even when I was doing this presentation, if you need the slides because, you want to review them later with some technology or what have you, each of the images that are on this PowerPoint are embedded with alt text. So, this computer laptop says MacBook Air with Google up on the home screen open. And so, because if you're relying especially on graphics for, let's say, a restaurant, you take pictures of all your beautiful food, okay? Or maybe if you're in farming and you're taking pictures of all your beautiful fruit and your beautiful packaging and all that, and you throw that up on your website, that's great. But people who have disabilities like fruit and almonds and things like that too, and they want to participate in buying those types of items. And so every single image needs to have alt text on it, so that person can say, can read out loud, their screen will be read out loud, hey, these are chocolate covered almonds with sea salt, or these are, dried apricots with chili powder on them, or whatever it may be as descriptive as possible. So you're giving as much information as possible. So that way that person doesn't have to call and say, okay, well, what's in this? How, what is I see that you have chili verde. How do you make that? What does it look like? Is it, whatever the situation may be, the goal is to provide as much information and ease of use for them, so they can participate just as a sighted or a fully hearing person can do, and so it may, well, and Kurt, I love that you say it's common sense. You're in the industry, so it's common sense to you. So when I started really kind of diving into this, it was not common sense to me. You know, it was like, wait, what? How is this? How does this even work? And so it really, if you've got, I see some people based on the poll results are not understanding or are still confused. If there are some issues that you're not understanding or confused about, let us know, because we want to make sure that you get as much information as possible. So that way you can take this information and employ it back to your businesses.
Let me add one thing to that common sense quote. So I think graphic designers, website builders, coders need to build a new common sense, right?
Right.
Common
I
sense
would agree with that.
could be dated, but it's really building a new visual vocabulary around a new common sense that solves these problems and issues. So if we can get to that level, we'll be having less of these issues. And certainly
Right.
with the platforms, if as designers you can complain to Squarespace or WordPress, whatever, it's like, you guys shouldn't be giving options, you know, for small type. Why do you do that? You know, have a minimum size, and then it just never happens. So, but that's not the case on the platforms.
Rochelle, I'm just taking a quick look at the clock, and I want to bring Tom back in again. Boy, I know I personally am in the midst of designing a website, and I've been uploading images. None of them have alt text in them because I'm old school, and it used to be optional. You put SEO language in there, and now it's got nothing to do with SEO any longer.
Nope.
So, Tom, why don't you come back on board?
Sure, just a couple things and why I'm passionate about this topic. First of all, I think it's good for business. A lot of my clients resist these sort of things, saying it's just unfair that the government's making us do it. But there are great benefits. There's a financial one, which Rochelle covered well. But if you do these things, it actually helps with search engine optimization. I've got a lot of my team is on the call here, and we're all about increasing sales for people through effective marketing, digital marketing. And so there's an advantage that way. The third thing is that I've seen 2 lawsuits, because I get it through Google Alerts, to manufacturers who are selling B2B. So the fact that a lot of the people that are kind of big targets on their back are e-commerce, government, medical, utilities, anybody who's kind of interacting with the financial, with the populace in a big way, it's spreading into the rest of us too. So, but I don't think you should look at it as a problem. I think you should look at it as an opportunity, because it really will help your marketing in the long run.
Great. Tom, I'm taking a look at the clock here and want to honor other people's time and plans for the morning. So we're going to pick this topic up again next week. Are there particular questions that anybody has that they'd like to let us know about now, so that Rochelle can take them into consideration when we get together again next week? If you'd go into the chat and type those in there now, that would be fantastic, because we'll make sure that Rochelle gets that list of questions. So if you click on the chat button, it will open the chat screen, and you can start typing those questions in now. Just type, hit return, because we'll be able to save the chat and pass that along to Rochelle. So if everybody would go ahead and pose whatever your questions are. And while we're waiting for that, Rochelle, one of the questions that I have for you, I appreciate the example you gave of the image with the Mac on the Macintosh lapbook being open on the screen, and with Google showing on the screen and so on. What is one supposed to do if you're working metaphorically with an image, like of a skier coming down the slope, in order to talk about a business needing to be flexible and responsive to the moguls that are going to come up, in their business world? Just how concrete does the language have to be?
Well, so I went back to this slide because there's a young lady in a racing wheelchair, and so this, this image is explained: young lady in a racing wheelchair with a smile on her face, which is analogous to, and you would just continue on with that language in your alt text. I mean, if you're truly providing an image of people in order to get your point across, then that needs to be explained. And so we'll see, as we go through kind of the latter part of the presentation, I have an example of Chipotle's accessibility statement that's an image. So in that, and that's all that's on the slide. In that image, I retyped out everything that's in that image. So that way a person who, has screen reading software will know, okay, here's all the language, in the image. So that way they're not excluded. So the more information you can provide, the better. And I think you should ask yourself, okay, if I were using this kind of software, what would I want to know? How would I want to, you would want to know the analogy just like anybody else. So put as much, Microsoft recommends like 2 to 3 sentences, but put as much information in there as you want, as you need to in order to get your point across.
And do we have to use the words image of at the beginning of the image, or that's up to their screen readers to worry about?
That would be up to their screen reader. So it's just all, and correct me if I'm wrong, but yeah, it's just truly typing in a description of what's in that image.
Fantastic. Tom, back over to you.
So we're gonna, end this baby at an hour, which is right at the edge of what I want to do. I always shoot for 45 minutes, but Rochelle is just too darn interesting. So, but if I were going to give people advice on the call, just real quick things you could do tomorrow is this alt tags. Really look at your alt tag. That's an easy thing for you to do or your web person to do it. I also think you should contact Rochelle and talk about getting a simple accessibility policy to put at the bottom of your website, which basically says, call me if you have a problem, but there's some legalese that should be in there. She's very reasonable in building those for you, and I highly recommend you contact her about it. It's a simple thing to do, and it's a start. And then really look at your colors and just make sure there's good, strong contrast. Bottom line is, like Kurt says, if you can read it, probably other people can too. If it looks a little soft to you, then it's a little soft. So with that, Rochelle, you're fabulous in every way. I appreciate your time. Everybody, thank you for your time for joining us. I am going to put this up on my blog. Also, just to warn everybody, I am going to send an email out again, inviting you all. At the bottom of my emails, there is a place where you can unsubscribe. So, it doesn't hurt my feelings, but I really do appreciate you attending, and I hope to see you all next week. So just so everybody knows, I will share the poll result is that 94% of us would like to have this topic next week. So that's what it will be. So,
well, and we didn't even scratch the surface. I mean, we're just getting into this thing. So please come back next week, and because I really, there's a lot more meat in kind of the technicality of this that I will be sharing with you all next week. So please do come back.
Great. Thank you very much, everybody.
All right.
Have a fabulous
Thanks, everyone.
holiday.
All right. Bye-bye.
Bye.